All right, so let's have one short video about the current legal framework around civil rights. And when we try to understand how civil rights gets applied in our political system today, we have to make one important distinction, and that is the distinction between the right that one has not to be treated differently by government, right, and the right that one has not to be treated differently by private employers, etc. And these are very different, issues, and different sets of laws are involved. These are laws, and this issue is the 14th Amendment. And so let me first talk about the right not to be treated differently by government. Now, of course, that is governed by the 14th Amendment, put in the Constitution in 1868, and that includes the Equal Protection Clause. No state shall deny to any person within its jurisdiction the equal protection of the laws. So the idea is that laws that treat people differently based on the group the individual is in must be struck down if they're not justified. That's the way we understand this today. But the constitutional amendment has certainly gone through some pretty dramatic changes in interpretation. And I've already alluded to these a little bit, but this is a chance to just put it all in one place and also to add some others to the list. So, of course, the first really important application of this amendment is in the case Plessy versus Ferguson in 1896, and that was the early case that suggested that segregated facilities were a constitutional, so separation is constitutional as long as equal, so separate but equal, right? And it's in 1954 when that case is overturned, with the understanding now that segregation is not equal, in that it sets up an inherent inequality because certainly the justification for separation is the assumption that one race or ethnicity is superior to the other, and so any time in which that situation is the governing value, clearly there's not equality. Now, in the same year, there was another case called Boiling versus Sharp, and in that year, the question came up: what about the federal government? Does the federal government also have to abide by the requirement to treat people equally under the law? The 14th Amendment, of course, says no state shall. And in this case, the issue was segregated schools in D.C. Now, D.C. is not a state. D.C. is a city that's kind of under the protectorate of the federal government. And so federal laws, to a certain extent, govern in D.C. And so the question was whether schools in the District of Columbia had to be desegregated. And the answer was yes, that in fact the federal government also has to extend equal protection to those who are affected by its laws. And this is through essentially the Fifth Amendment. The Fifth Amendment includes a due process clause. The due process can't take life, liberty, or property without due process of law. And the assumption, and that same phrase is in the 14th Amendment, but the Fifth Amendment does not have the Equal Protection Clause. And so the notion was that these two things kind of go together, due process and equal protection, and that one can read that into the Fifth Amendment. Now, again, this is another one of those examples of it's kind of a creative interpretation that solved the problem for us. We didn't have to amend the Constitution to provide for that. And it made a huge difference to people affected by federal law. Now, another 10 years later, we get to another a case about urban residents. And this issue has to do with the way that maps are drawn, congressional election maps. And let me just kind of illustrate for you here. This is a map of the U.S., and all of these little bits here are congressional districts. And you can see that in places with high population, they are extremely small geographically, in contrast to places with not as many people, right? So very small districts geographically, lots of people tightly packed in. Now, coming into the beginning of the 20th century, as the country was industrializing, as people were moving into the big cities, what was happening is that the maps that had been drawn in the past were reflective of a very rural society. Many of the maps, the districts, were pretty much the same geographic size, almost like a jigsaw puzzle with evenly placed sized pieces, right? And I'm going to show you, if you take a look at the map that's showing right now, this is a simulation. Some of it's cut off, you don't need to see all of it, but it's a simulation of congressional maps, and it's going to reset to the beginning of, oh, it's actually going backwards. Interesting. So what you'll see is right now it looks like kind of what we're used to, some very small geographic districts. When we get back to before 1972, you'll see that that wasn't the case. There was a very important moment when the court decided that urban residents were not being treated equally under the law because their districts were the same size as a rural district, which meant that they had less representation per capita. See, here's where we get to the point where pretty much all the districts are the same geographic size. And the maps, if you'll notice, for the past 50 years really were very similar. The maps didn't change very much at all, even though, you know, millions and millions of people were moving into large cities. And so this was setting up a really an intolerable situation of overrepresentation of rural people and an underrepresentation of urban people. And so a case came before the Supreme Court claiming that this was a violation of the 14th Amendment and that urban residents were being denied equal protection. Now, the court at first did not want to rule this way, and it took a couple of cases to get to the point where they used the 14th Amendment to require what we now call one person, one vote, so that states would have to be district maps would have to be redrawn to represent an equal number of population in each district. And this dramatically changed the way the system works. It gives much more voice to urban residents and much less voice to rural residents. So we're still going back in time, and you'll notice the South is going to disappear pretty soon. That's the Civil War. And we're going back to the origination of the country. All right, let me go back to the PowerPoint. So that was another issue, another kind of creative use of the 14th Amendment to solve an important problem, which was this unequal treatment of urban residents. In 1971, we get to the case I've already mentioned, which is Reed versus Reed, that extends 14th Amendment protection to women and considers persons to include this crucial demographic. And then in 2015, gay people who want to get married. Now today, a very crucial issue is the lack of what calls equal protection that's being highlighted by the Black Lives Matter movement. Clearly, when we talk about equal protection, and when they put that phrase in the Constitution in 1868, the standard of treatment of former slaves was clearly going to be one of abuse if there weren't some requirement that the law protect those former slaves. And so, to a certain extent, the Black Lives Matter movement kind of highlighting the unequal treatment of people at the hands of police officers is hearkening back to that very early understanding of equal protection, right? Now, the 14th Amendment, when it gets applied, I'm going to switch you to a chart that's in your textbook. The 14th Amendment is understood now to speak to discrimination in many different spheres. But the court has recognized that different kinds of discrimination, what you might call classification even, are justified. And so for those cases, the bar is not quite as high for justifying those kinds of classification. So for instance, classification based on age. There are many, many ways in which the law treats us differently based on our age. And I'm sure some of those things are coming to your mind, right? The voting age, the drinking age, the driving age, retirement benefits kicking in. All of these things treat us differently based on our age. And for that kind of a categorization, what the government has to do is pass what's called the rational basis test, which is that there is some purpose that the government has, and that the classification is related to that purpose. This is a fairly low bar. It's not that hard to get these kinds of things through. But we have an intermediate classification grouping as well, and that is based on classifications based on gender or sex. And in those cases, there's a higher bar. One has to have a substantially an important government purpose, and it has to be related. Now, it's a slightly harder test to pass, and you can think of one of the main areas in which this kind of classification had been justified was treatment by the military. So for many years, of course, women could not serve in combat positions. That's lifting now. It's not lifting because the court forced the military branches to reverse that policy. It's because that's a policy that's being changed, that's been driven by the military itself. But we still have on the books the rule that men have to register for the draft and women do not. But I don't anticipate that that's going to last very much longer. There's a bill in the Congress right now to reverse that, and I would be surprised if that difference stays very much longer. The toughest categorization to justify are categorizations based on race and ethnicity and national origin. Those have to pass what's called the strict scrutiny test. And you have to have a compelling government purpose, not just important. And it can't be achieved any other way than the way that you're doing it. The only classification that I can think of that passes this test are some forms of affirmative action. Now, affirmative action is not terribly widespread at this point. It's sometimes I think it's exaggerated in its importance, but affirmative action, for instance, in government contracting, if you are going to compete to be able to spend money, to be able to earn, be a government contractor, then you have to affirmatively hire and promote African Americans, which doesn't mean that you hire or promote people who are unqualified, but that isn't. It's okay for that to be for race to be a factor in those decisions. Another form in which we see this is affirmative action in universities admissions. And so some colleges, in order to have a kind of a more diverse learning environment, will give some form of preference based on race. But the court, two things to say about this. Number one, the court has reined this in pretty dramatically. It's not legal to simply give a point advantage. It has to be one factor among others, and one certainly cannot hold spaces aside. And so there have been some recent cases that have really kind of I guess say pulled back on affirmative action as a sanctioned policy, but it was upheld this past year in a case in Texas. The court upheld the use of race in the admissions process in the very kind of limited way that they use it in Texas. But the second thing to say is that states have different policies on this. So the state of California does not have affirmative action in any of its universities, nor in its government contracting. And so, so in California has a very small footprint, only federal contracting, basically. So that's the legal framework around being treated differently by government. Let's talk now about the right to not to be treated differently by private employers, by businesses, in public accommodation, like in restaurants, hotels, and things like that. The framework here are federal laws, including the Civil Rights Act of 1964, the Americans with Disabilities Act, and also state laws that provide additional protection that the federal law does not. And I'm going to come back to that in a minute. But let me talk about the Civil Rights Act of 1964 a little bit more in some detail. This is a very important piece of legislation. And what it does is it sets up what's called the Equal Employment Opportunity Commission, which is going to mediate complaints, and it also and they would do investigations, and they're the ones that would decide whether there's cause to think that a discrimination happened. And if they do not find, and other legal mechanisms are not used until the EEOC has finished its work. So in other words, one doesn't simply file a lawsuit if one thinks one's been discriminated against. You have to first kind of go through this EEOC step. And then the EEOC kind of gives permission to sue if one is not happy with the decision of the EEOC. The other crucial limitation is that the provisions only apply to businesses with more than 15 employees. So small family businesses are not covered by this. It also gives some exception where a bona fide occupational qualification is present. So, for instance, it is under this law illegal to discriminate on the basis of religion, but if you're hiring a priest, of course, you don't have to hire somebody Jewish. It's a bona fide occupational qualification. Now, the way that the law works is that it sets up a list of groups or bases on which discrimination is not okay under the law. And these include race, national origin, religion, sex, disability, pregnancy, retaliation, sexual harassment, equal pay, and age. And things that are not on that list are not things that one considers to be discrimination that has a legal ramifications at the federal level. And let me just show you an example how these statistics look. You can find the enforcement statistics at the Equal Employment Opportunity Commission, and let's just look at sex-based discrimination charges. And you can get a sense of, in 2015, you can't see the other side, but in 2015, there were 26,000 complaints nationwide. And most of those complaints, only 6% of those claims resulted in a withdrawal of the case with benefits, and in 62% of the case, this is this statistic here, it was found that there was no reasonable cause to think that there was sex discrimination. It's actually a pretty difficult thing to prove to the EEOC. Just one instance is typically not enough to prove sex discrimination or any kind of discrimination. So the law is set up to make it fairly or not very onerous or burdensome for businesses. That's certainly the case. There's one really important category that you'll see is not actually on this list here explicitly, and that is sexual orientation discrimination. Now, up until fairly recently, sexual orientation discrimination was not a cause for concern at the federal level. There was no prohibition on that at the federal level. That was something that was one could find in some state laws. Now, first, let me just show you some of the maps where we can see some of the states that do provide sexual orientation protection. The purple states are ones that prohibit discrimination based on sexual orientation and gender identity in employment. So if a state is gray or light blue colored, then in private employment, the issue of sexual orientation discrimination is not an issue. Certainly if an employer finds out that you are gay and fires you because of that, that's okay. Now I'm gonna come back to this. It's not exactly correct right now, but this is the case most of the states. And another issue that is really crucial in this realm is public accommodation discrimination. So the question about whether a restaurant, for instance, can refuse to serve, whether a bakery, we've heard lots of cases of bakeries, for instance, refusing to make cakes for gay weddings. The green and yellow states, these are states that prohibit discrimination based on sexual orientation in public accommodation. So if you have a business and you don't want to sell to someone who is gay, only the green states are places where that's problematic. Now, I just want to add something to this discussion, and that is that there's a change afoot right now. Last year, the Equal Employment Opportunity Commission handed down a decision in which they interpreted sex discrimination as including sexual orientation discrimination. So in other words, if you were fired for being gay and you are a man, then you wouldn't have been fired if you had been in love with a woman. And so to a certain extent, this sets up a case of what they're referring to as sex discrimination, and they're claiming that this is prohibited by the Civil Rights Act of 1964. Now this is a pretty dramatic difference in interpretation of the Civil Rights Act, and there's a case that was announced last month in which the court found that this was not an appropriate reading of the Civil Rights Act in 1964. So things are kind of up in the air right now about this, and we were over the summer talking a lot about bathrooms in North Carolina. This is probably going to be the next issue that's going to get some attention, unless it's the case that court after court after court strikes down this interpretation by the EEOC, and maybe the policy will just go away. But if there are courts that take different positions on this, then certainly it's going to get a lot more attention in the public eye. Okay, so hopefully this is somewhat helpful characterizing the difference in legal framework if you are treated differently by employers, businesses, and if you are treated differently by the government.